Welcome to today's episode where we'll be diving into the most significant developments in the UK competition law, particularly in the realm of digital markets. And the Digital Markets Competition and Consumers Act, known as the DMCCA, it represents a major step in the UK regulations in terms of digital markets. It has been fronted as the most capable in terms of reining in big tech in lieu of conventional competition enforcement. And to help us unpack what all this means, I'm joined by Professor Oles Andriychuk from Exeter Law School. His specialty is in competition law and digital markets. He's also engaged in several key projects geared towards not only understanding, but also informing and sharing ongoing regulatory reforms of competition in the digital economy. To name a few, he serves as the OECD-appointed expert reporting on Ukraine's competition law and policy. He's also jointly with Professor Podszun, the principal investigator for the UK under the banner, Shaping Competition in the Digital Age, a project that examines the effectiveness of the DMA, the DMCCA, and the amended German Competition Act. He's also the founder and directs Digital Markets Research Hub, a YouTube channel which offers insights from leading competition law experts on a weekly basis, which I must say is quite engaging. So do subscribe, dear listener. Professor, thank you for joining us today.
Thank you very much. It's a real pleasure, Isaac. Great initiative, and it's a very big honor for me to come back to Newcastle, the school I was working in, and it's a real pleasure to discuss this fascinating topic.
So, starting from the beginning, what do you think really prompted the UK to adopt the DMCCA? Was it mainly about tackling the power of the dominance of big tech, or does it reflect a deeper shift in how we think about competition in the digital economy?
That's the most important question, exactly. What is the purpose of such revolutionary, in many respects, legal regime, which allows for the enforcer so much in terms of tailoring obligations, in terms of identifying instances of non-compliance. And obviously, we all know how important digital markets are and how rapidly this importance is growing, is increasing. We all live, function as digital species, and the power of largest online platforms is increasing exponentially. Add to this AI and all the hype associated with it. It's self-evident. Competition law tries to minimize harmful effect of unilateral conduct of those people who have trained their muscles, who became too strong, and they can act independently from their competitors, customers, and consumers, to the detriment of more effectively functioning, more fairly functioning markets. And evidently in the markets in most of digital markets, we see this network effects. We see the tendency for winners to take it all or take most, leaving competition only for the losers, so to say. And this is a systemic trend which has been very well described, and we understand that those sporadic reactions by traditional competition law are by far insufficient to change the modus operandi of the industry. Furthermore, in the UK, we understand that I'm talking about the UK of 2020, when this idea has emerged. Back then we were mindful how important it will be for the UK to either have their own big tech companies or at least have their important regulatory capacity to shape and steer and limit the frivolous conduct and of all major players, none of them coming from the UK itself, of course. Because competition law reacts to anti-competitive behavior, and because the standard of proof is increasing very rapidly, the burden of proof is getting heavier and heavier. It is on the enforcer to prove, and to prove without, to prove the conduct which defendant can always refer to 1001 procedural errors and some minor mistakes which can be easily amplified if your pockets are deep and if you entrusted your case to professional, high top-tier professionals in the area. So such sporadic responses are seldom sufficient to even to limit the omnipotence of big tech, let alone to steer it in a more strategically long-term perspective fashion. With this in mind, almost a consensual agreement by all non-biased stakeholders has been reached in early 2020s that something in addition has to be introduced, something which a legal system or legal regime which would allow, in addition to traditional competition rules which react to anti-competitive behavior, to introduce rules which would be applicable ex ante for the companies which constitute kind of big significance for the market. We designate them with the status nowadays of strategic market status, SMS. In the UK, we opted for the most bespoke fashion of this regime, because in Europe we went in slightly, so the two polarity is bespokeness and flexibility of the discretion of the enforcer on one hand, or automaticity of the system on the other. The DMA is closer to the automatic system. So once a company is designated, once the company achieves quantitative threshold, unless something extraordinary happens, we designate this company with the status of gatekeeper. Once designated, it automatically becomes subject to a very long catalog of obligations. So the system is by far not automatic, but it's moving towards this end of the spectrum, still being closer to the center, of course, because the discretion is there. In the UK, we opted for an even more discretionary model. It's not absolute arbitrariness, but it's moving closer to this side of the spectrum, where the competition and markets authority has the discretion to designate, and I obviously caricaturize this, designate pretty much each big tech company or each undertaking which does have significant position in the market, durable position, and which has this impact on the market. And also what is most interesting in this regard from juristic point of view, rather than listing catalog of obligations, we decided to entrust the CMA, Competition and Markets Authority, with the mission to tailor obligations for conduct requirements for each specific designated undertaking, or each specific digital activity of each specific designated undertaking, ad hoc, depending on how they see what is needed. This is a very interesting mechanism, because it gives you an opportunity as an enforcer to tailor obligations for the specific gatekeeper or SMS, based on your understanding of what is needed for the market, where exactly the systemic problem is, where this entrenchment can be eased, where this bottleneck effect is present, how can we stimulate the market. So you are a kind of a neurosurgeon. You see which specific vessels are blocked and how precisely you can use your digital toolbox to minimize the harm or to trigger competition. So it's a very micromanagerial exercise, and if applied and if done prudently, it can deliver effectively very quick and tailored results. However, there is backside of it. There is kind of side effect of such discretion. This discretion is a double-edged sword, because it is a discretion to intervene and to tailor obligations, but also discretion to sit on your hands and wait and collect more evidence and make yet another remarkable market study about how the system is evolving and what will happen in the following future, which is also important, which is also a normative choice, essentially.
Yes.
So the DMCCA is a very flexible, open textured instrument, which allows for a very proactive approach to shaping competition in digital markets or even shaping digital markets themselves. But equally, it allows you to do nothing. So the enforcers are not required to designate anybody. Even after they designate anybody with this strategic market status, they are not under the duty to impose conduct requirements. And even if they impose conduct requirements, they are not under the duty to impose long catalog of conduct requirements. They can choose only a handful, implying that the more targeted, the better it is for the economy, for business users, and for all involved. Even if they choose to impose several conduct requirements, they are not under the duty to find instance of non-compliance. And also we have efficiency defense, however paradoxical it may sound in the system. So I think this system is reflecting best the trend of politicization of competition policy or competition enforcement. In the previous decade, there was a mantra that competition agencies must be independent from the government, that they have professional expertise which should be neutral, and the political winds should not affect the scrupulousness and neutrality of competition authorities. This can be only done if we believe that economics is an objective science, where the results have objective, almost like physical science, natural science value, and that are non-interpretable or interpretable only on the margins. And we all understand that economics is a toolbox as well, and you can change if parties change their consultants, the results of the 50-50 case can be very different. Which is, again, it's not a bug, it's the systemic feature of how the system functions. And thus, once we start abandoning the belief that competition authorities should protect for its own sake or for the sake of the functioning of the system their neutrality, and we started understanding that they are political beasts, to some degree at least, then the question is, why shouldn't they be subordinated to the democratically elected governments? Or at least, why shouldn't they coordinate or at least listen to what the government is saying to them? So from the purely descriptive point of view, I think that the system in the UK epitomizes best this trend. But from the normative point of view, because my normative position is intervene fast and don't be afraid from making regulatory failure.
Yes.
I am disappointed because the position of the current government is more oriented to growth and to welcoming investment from big tech itself.
I have been thinking about, as you've said, I have been thinking of what the aspect of the thinning between the line of politics and what it takes for the regulator to be independent. And thank you for bringing it up. I must say, since the new head of the CMA is evidently someone who was working in big tech, is this some form of, as you said, is it some form of revolving door policy where we see, oh, people in government, they get into regulation, or the other way around as well?
I think the phenomenon or the problem of revolving door in competition cluster is pervasive, or the phenomenon, I would rather say, because I don't see it as per se pathological situation. People change their careers, they change their sites. It's a problem, but it's not a sign of kind of malicious behavior in a sense. In general, speaking of this specific situation, I am normatively very against the approach where we can rely on proportionality of the DMCCA, because the very philosophy of the DMCCA is about asymmetric regulation. So it will never pass the proportionality test. What's the point in having it if you want to have things proportionate? It is an attempt to equalize the disequilibrium. rather than just to make some incremental improvements. So yeah, I believe that the DMCCA should be enforced much more proactively, but this is my normative belief. As an academic, trying to understand systematic kind of evolution of the system, once the monopoly of economics, the monopoly of holding the economic truth has been dismantled and has been completely discredited, perhaps, we realize that competition policy is not an autonomous. Technically, it is institutionally it is autonomous, and it should remain to be. But conceptually, it's not a policy which can be done neutrally. It must have it has to be associated with specific ideology, and there are probably many other better ways, but probably the most mainstream way is elections. So the current government, in my view, is doing what they have to do. They try to pursue their policy. I disagree with the policy, but I think that the mechanics of things, how they do it, reflects that this trend. The competition policy has been it has lost its status of natural science, and the implication of it that it is fine for competition policy becoming yet another governmental policy with many reservations and many caveats. It is not it will be inadmissible to have direct kind of interventions, but at least some coordination is necessary. In terms of personalities, I'm not privy to the nuances in terms of who. I know the background from the CV publicly available on the website and conversations at different conferences, but I think it's kind of easy target, so to say. We can. I don't have much to say about the specific personality which chair in such important institution.
In terms of when you look into the DMCCA in terms of implementation compared to what was happening on the other side in the case of the DMA, in terms of stakeholder engagement, how do you perceive it? Since it seems like everything is quite discreet, or would I say in terms of workshop, you'd find it done, or let's say whoever is running the workshop, it seems to be more like industry rather than the CMA itself, where the industry invites an official of the CMA to conduct it. In the other case, in terms of the DMA, you could actually, it was much more where, as long as you're a consumer, you could have access, be it on the online. So do you think that is something in terms of epistemic issues, access?
I think it's a very important issue for researchers to look at and to compare to jurisdiction. When we do a comparative analysis, we try, it's our tendency, natural tendency, to contrast two jurisdictions. And in the DMA, the role of stakeholders is higher. In the DMCCA model, the role of stakeholder is low, or other way around, depending on our conclusion. I think the role is quite similar. It's quite understandable when we talk about business users, for example, as most active stakeholders, most strategic. They know what they want and they know how to calculate the response of the enforcer. I think they are active in both jurisdictions, and they operate under the principle first come, first served. Clearly, if you are vertical search operating some, I don't know, hotel or shopping services, you will be saying that the very ethos of the DMCCA is about restoring this specific core platform service, restoring competition or bringing more fairness for this core platform service. If you are an app and or alternative app store, you will look at this regime through the prism of your business interests, which again is absolutely fine. And they know how to communicate the message to both jurisdictions. What I have noticed, however, and to my surprise, when the DMA was discussed, and I compare it with how the DMCCA was discussed, I have noticed again, with a tendency to contrast something which is probably very similar and probably lack of my understanding of nuances, but it was very clear that a lot of stakeholders have been invited to comment on the DMCCA or on the Digital Markets Competition Consumer Bill at that time, particularly in the House of Lords and in many other venues. But the final result of all these discussions was pretty much the same as the original bill, with tiny changes, and I wouldn't be particularly enthusiastic in supporting all of these changes, because some of them are particularly provisions of Section 29 are still beyond my comprehension, or some of them at least. I don't see coherence between how you can do efficiency defense and behind the technical side of how you can do it step by step. Contravariant benefits exemption in the vocabulary of the DMCCA. At the same time, that during the DMA discussions, the stakeholders were vocal, but the Commission was advocating the principle or the vision that many of the stakeholders are biased, they are astroturf, they represent the voice of association of something, but in reality they are channeling specific message. So we try to insulate ourselves from the excessive noise generated by thousands of stakeholders, and we try to do the technical job separately. So we didn't see such engaged discussion, in my view at least, as in the UK. And yet the bill, the proposal, has undergone significant transformations. So it's a kind of strange situation. We have very vocal stakeholders during the DMCCA with pretty much zero outcome, and vice versa within the European Union. I wouldn't thematize this, and I wouldn't say that this is something, revolution. It's just a sporadic observation. Maybe I'm happy to be proved wrong, and it's not something which is pivotal for me. In any case, what is systemic for all is that stakeholders represent their version of truth, and they are legitimate to do it. They are eligible to do it. That's absolutely fine. My concern is that behind these dispersed voices of all business users, and there are many, and the voices are very eloquent, elegant, and very well calibrated, and singing very nice melody like sirenas.
Yeah.
The broader public mission of the regimes can get lost. My belief, my normative belief, or somehow my understanding of the system is that we only have the magazine. The magazine has limited the space only for limited amount of bullets or weaponry. I'm from Ukraine. I use this vocabulary. Sorry. And if you start hurting big tech too often, it will backfire on us in one way or another. They know how to backfire, how to caricaturize and mutate the DMCCA or the DMA. So we have to operate under the presumption that we have limited shots in our magazines, in our machine guns, and we have to use them prudently, strategically, rather than on first come, first served, because the obligations are so hard to comply with that if you are a private litigant with significant injection of third-party funding, it is so easy now to identify instance of non-compliance and to make the gatekeeper to pay for you. But this is there are some elements of zero-sum game, in my view. I should finish by saying that not many agree with me on this.
Okay. So, and finally, so far you've been working under the joint partnership assessing digital competition law development. So this has positioned you to have an overview of what is an ideal aspect in terms of moving forward. You could pinpoint one or two things from this regime and this regime. What thing could you, or maybe one or two things you could tweak apart from the countervailing benefit exemption, which, as you've said, 29? Is there something else that you've actually pinpointed and said, oh, yeah, could you let us in on that?
Thank you very much, Isaac. I think that what is really important in the system, and again, I will refer to the issue which I'm in minority within, namely, I think it's not about forcing or identifying enthusiastically instances of non-compliance and then penalizing the wrongdoers with heavy fines. It's about trying to find a semi-amicable solution, trying to develop regulatory dialogue. My starting point in this regard is that they are native speakers in these ecosystems. They have designed these ecosystems many years before it became mainstream. They already working on something which is completely terra incognita for us. We are still dealing with the problems of the past, trying to outperform them in front of the audience, of their audience in their domestic stadium, having like a third amateur club with 3 missing players playing against top tier club, being spurred by the best, dopings and all the circumvention techniques they know. It's naive. So we can hurt them, we can make their life difficult, but there is no point to do it for its own sake. We have to use it as a bargaining chip. But for this, we need to know what I mean Europe or UK, yes, or Europe more generally. We need to know what is in our best interests. And here I acknowledge that many people, many leaders understand this digital sovereignty issue of digital sovereignty differently. So it's hard to find consensus. If you ask me how do I see it, I would probably say that we need to build our own Eurotech. I know that it is unrealistic though, and it would be so naive to embark on this journey, but without having, and yet it doesn't make it less important. I think without having our own Eurotech in the 21st century, when these digital games just started being played, we will gradually be decreasing from winning Champions League to playing in Champions League, and then being happy to qualify in Champions League, and maybe in 5-10 years time we will move to Europa League or Confederation League, or there are many other esoteric leagues, and we will still be fine because our starting position was absolutely astonishing. But it is a gradual, not catastrophic, but gradual, slow but consistent and stable decline.
Thank you for that. Professor, this has been incredibly insightful, and you've helped us to actually see not only what the DMCCA and the DMA does, but why it matters, both legally, conceptually, and for the entire digital market. Thank you so much for sharing your expertise, and happy to have you. Thank you.
Thank you so much, Isaac.
Thank you so much. Thank you.